5 days notice. What happens if your Florida land lease is terminated? In parts of Florida, you can receive a notice that gives you literally 5 days. 5 days to fix a violation or risk losing possession of your home. Not because you stopped paying a mortgage, but because you violated a land lease agreement. And most people who buy into these communities do not fully understand what they are signing. Today, I want to walk through this as calmly as possible and clearly what land lease actually means, who it really affects, what triggers termination, what the legal mechanics look like, and what you can do immediately if this ever happens to you. This is not legal advice. This is structural education. And if you're relocating to Florida, retiring here, or investing here, this matters. Let's start at the foundation. In a traditional home, you buy the structure and the land. You own the dirt. You own the bundle of rights that are attached to it. That bundle includes possession, control, transfer, equity, and long-term appreciation tied to that land, the dirt itself. In a land lease community, you buy the structure. You lease the dirt underneath it. That means your rights are governed by a lease agreement, not fee simple ownership. And that distinction changes leverage. A lot of people say, well, I own the house, so it's basically the same. It's not. A condo owner owns a fractional interest in land. A land lease resident does not. You own improvements. You lease location. And in Florida, location is the appreciating asset. Now, here's why these communities exist. Developers retain land because land appreciates. Land creates reoccurring lot rent income. Institutional investors like predictable cash flow tied to appreciating corridors. By separating the structure from the dirt, they lower the purchase price entry for buyers while retaining the long-term upside. For buyers, this can mean lower entry price, prime location access, amenity-rich communities, lifestyle benefits, So this is not automatically bad, no, but it is structurally different. And structurally different matters when conflict happens. Yeah. And let's clear up something else. When people outside of Florida hear land lease, they picture distressed trailer parks. That is super outdated thinking, just so you know. In Florida, land lease communities include 55 plus retirement neighborhoods, gated developments, waterfront enclaves, golf communities, etc. Some homes sell for $300,000 to $600,000 plus. These are primary residences many times. Often for, yes, retirees who sold paid off homes elsewhere. So imagine this. You sell your home in Ohio. You move into a beautiful 55 plus Florida community. You pay $380,000, let's use, for the structure. You feel secure. You have no mortgage. Then a lot rent increases $150 per month, if not more. The following year, it increases again. Insurance, pass-through costs really rise. You dispute part, at least, of the increase. You withhold a portion of payment. You believe you are standing up for fairness. And then you receive a notice. Now, you're not arguing about fairness. No. You're operating under contract law. That's the shift most people don't anticipate. Yeah. Let's talk about what triggers termination. Most lease agreements define default clearly: non-payment of lot rent, late fees, stacking, past cure period, violation of community rules, unapproved modifications, subleasing without approval, attempting to sell outside of approved channels, escalation clause disputes. Escalation clauses are important. Many communities increase lot rent annually based on fixed percentages, CPI formulas, or market adjustments. If a resident refuses to pay an increase because they believe it's unfair, that refusal may require and qualify them as a non-payment under the lease. And the lease governs no personal belief, not emotion, the contract. If default occurs, the community typically issues a notice to cure. This document outlines the violation, the amount owed, and the deadline to resolve it. Some cure periods are literally 5 days. Some are 7, some 15. It depends on the contract. If the issue is not cured within that window, the community may file for eviction. This is not a mortgage foreclosure. It is landlord-tenant eviction, which often moves faster, especially in Florida, because legally you are leasing the land. And depending on the contract language, outcomes can vary widely. Some agreements require removal of the structure. Some allow resale with restrictions. Some allow lien attachments. So not all communities operate identically. That's why reviewing your specific lease matters. If you ever receive a notice like this, the first step is simple. Do not ignore it. Pull your lease immediately. Review the cure period. Review the default definitions. Review attorney fee provisions. Review arbitration clauses. Review resale rights, if any. Document every communication and consult Florida real estate attorney experienced in landlord tenant and landlord lease, because that matters. Time is your leverage at this point. Silence removes your leverage. Hoping it resolves itself is not a strategy. No. Now, let's talk prevention. Before purchasing in a land leased community, ask for the full agreement. Ask for 5-year lot rent history. Ask how increases are calculated. Ask the remaining lease term. Ask who owns the land. Is it a small operator? Is it a national portfolio? Ask about transfer restrictions. Ask about community approval requirements. Ask what happens if land ownership changes. Ask what happens if you need to sell quickly. Ask what happens if lot rent doubles over 10 years. Those are structural questions. And believe me, they're not emotional ones. Here's the structural insight deeper. Land lease shifts appreciation upside to the landowner, okay? That's how it is. You participate in structure value. They participate in dirt value. And in Florida, dirt in prime corridors is what constitutions go on. That's why these portfolios trade for billions. That's not accidental. It's structural. Land lease is not automatically bad, though. Don't take me wrong. But it is contract-driven ownership. If you own the structure, but not the dirt, your power comes from understanding the agreement before you sign. In Florida, ownership is layered. And before you commit capital here, you need to know which layer you're buying. Here, education is leverage. If you found this helpful in any way, subscribe for more structural breakdown of the Florida market. Because here in 2026, surface level advice is expensive.